Ready? 3, 2, 1, start. The present matter before this Honorable Court pertains to a writ petition filed under Article 226 of the Constitution of India, wherein the petitioner seeks to challenge the impugned order passed by the competent authority on the grounds of violation of natural justice and arbitrary exercise of power. The brief facts of the case are that the petitioner, a government employee, was issued a show cause notice dated 10th March 2023 alleging misconduct in discharge of his official duties. In response, the petitioner submitted a detailed reply by refuting all the allegations and seeking an opportunity of personal hearing. However, without considering the petitioner's representation, the authority proceeded to pass the final order by imposing a major penalty and thereby terminating the petitioner from service with immediate effect. The primary contention of the petitioner is that the impugned order is violative of the principles of natural justice, particularly audi alteram partem, which mandates that a person shall be heard before taking action against him. It is a well settled principle of law that any quasi judicial authority or administrative body exercising disciplinary jurisdiction must adhere to the fundamental principles of fair hearing before passing any adverse order. In the present case, the petitioner was denied a proper hearing and no reasoned order was passed dealing with the contentions raised in the reply to the show cause notice. The learned counsel for the petitioner places reliance on the judgment of the Honorable Supreme Court in Menka Gandhi versus Union of India, wherein it was held that any action must conform to the twin test of reasonableness and fairness which affects the rights of an individual. The Honorable Apex Court observed that procedural fairness is an essential ingredient of law, and any decision which lacks due process is liable to be struck down as arbitrary and unconstitutional. Further, it is submitted that the competent authority, while passing the impugned order, has acted in violation of the statutory provisions governing the disciplinary proceedings. The applicable service rules mandate that before imposing a major penalty, a full inquiry must be conducted wherein the delinquent employee is given an opportunity to defend himself by cross examining witnesses and producing documentary evidence in support of his case. In the present matter, no such inquiry was conducted, and the order of termination was passed in a mechanical manner, which is rendering the entire action unsustainable in the eyes of law. Per contra, the learned counsel, appearing for the respondent, submits that the action taken against the petitioner is legal and justified as the charges against him were serious in nature, and due to this, there was the need for strict disciplinary action. It is contended that the petitioner was given ample opportunity to respond to the allegations, and his reply was duly considered before arriving at the decision. The respondent relies upon the decision of the Honorable Supreme Court in State Bank of Patiala versus S.K. Sharma, wherein it was held that violation of the principles of natural justice cannot result into injustice in every case unless it is shown that prejudice has been caused to the affected party. In rebuttal, the learned counsel for the petitioner submits that the question of prejudice does not arise in cases where there is a complete denial of the right to a fair hearing. In D.K. Yadav versus JMA Industries Limited, Honorable Supreme Court categorically held that where an order is passed in violation of principles of natural justice, it is void ab initio and cannot be sustained merely on the ground that some justification is provided later. The petitioner therefore prays that the impugned order be set aside and appropriate directions be issued for reinstatement with full back wages. Having heard the learned counsel for both parties and upon perusal of the material on record, this honorable court is of the considered opinion that the present writ petition deserves to be allowed. It is an established principle that any authority exercising quasi judicial power must pass a reasoned order after affording a proper opportunity of hearing to the affected party. In the instant case, the termination of the petitioner without conducting an inquiry and without assigning detailed reasons is a clear breach of the principles of natural justice. The respondents are directed to reinstate the petitioner in service with all consequential benefits. However, considering the peculiar facts of the case, it shall be open for the competent authority to initiate fresh disciplinary proceedings against the petitioner in accordance with law. With these observations, the present writ petition stands allowed. There shall be no order as to costs. The copy of this order be given to both the parties. Stop. ये 775 शब्द हैं, ये हमने किया 122 की स्पीड से.